All right, I'm going to begin tonight's lecture on Griswold versus Connecticut, which is the first full case we'll be reading for our module on constitutional interpretation. Very exciting. By this time, I'll be assuming that you've read the PDF file entitled Griswold versus Connecticut, along with the first two cases that sort of introduce it. The first of the introductory cases is this case of Buck versus Bell, a very alarming case. And what happened in this case is that a woman had been committed to a mental health institution. She had a child out of wedlock, and the state, seeing this, attempted to have her sterilized by salpingectomy. And of course, she fought this to the best of her abilities, but ultimately, when the Supreme Court heard the case, they found that the salpingectomy was constitutionally permissible. In other words, there is nothing in the Constitution that prohibited this procedure from transpiring. And the reasoning is particularly interesting to me, as I'm sure it will be to you. Interesting in a strange way, because it doesn't quite seem to be appropriate. But they've used a critical premise in their reasoning to permit this sterilization. They've said that the state, the government, in other words, can call upon some of the best citizens to give their lives. And so from a greater case to a lesser case, the state may call on some of the bad, in their words, citizens to give up their reproductive rights. The state is, the Supreme Court makes replete reference to a person who would sap the energy of the state, such as Carrie Bell. And because she's just basically a parasite in their eyes on the resources of the state, of course, they can have her sterilized. Now, you might worry about this premise, as I do. Well, of course, this legal reasoning is obviously crazy, but I've tried to develop maybe some way that you might think you could push back against this kind of reasoning in Buck versus Bell. You might recall that in previous modules, I introduced Philip Bobbitt's modalities of constitutional interpretation. And one of the modalities of constitutional interpretation is that of structure. When one makes a structural argument, they appeal to basically the purpose of government. And from the purpose of government, they try to make an argument about why some practice either is or is not conducive to that purpose. So let's see if we can try a structural argument against this idea in Buck versus Bell, that if the state can call on the best citizens to give up their lives, it can call on worse citizens to do things less than death, right? So here's something that you might think. You might think that if the state can call on the best citizens to die, the state must have unlimited power. However, it does not seem to be the purpose for which the government was created that it have unlimited power. And since such a practice would run afoul of the purpose of the government, it's not conducive to its purpose, you can make a structural argument that such reasoning is impermissible. And what I've just done there is basically try to find an absurd consequence of a kind of reasoning, and then show how it leads to an absurd consequence or a contradiction. And after it leads to a contradiction or an absurd consequence, show that the reasoning that gives us or generates the absurd consequence ought to be rejected. This is a form of reasoning called reductio ad absurdum. You try to reduce something to absurdity. So if the government can call on their best citizens to die, says the Supreme Court, then they can ask anyone to do pretty much anything, including undergo sterilization. This is the argument that the Supreme Court made in Buck versus Bell. But we might think if the government can ask anyone to do pretty much anything, they'd have virtually unlimited power. But the government isn't supposed to have unlimited power. And so if the government isn't supposed to have unlimited power, any practice that allows the government to have this unlimited power should be disallowed. And since this legal reasoning generates this kind of unlimited power, it's grounds for rejecting that kind of legal reasoning. That's the argument maybe I wanted to run for you if you were not on board with the Supreme Court's decision in Buck versus Bell and found it as outrageous as I did. So far, this is just setup. The second of the two cases that sort of is the precursor to Griswold versus Connecticut, the subject of today's lecture, is this other case, Skinner versus Oklahoma, ex rel. Williamson. All right. So basically, what Oklahoma does in this case is they develop a law that I'll call 3 strikes and you're out of your gonads, right? If you commit 3 strikes, if you commit 3 serious felonies, you would be sterilized. You would not be permitted to procreate. You would not have children. And so Skinner commits a wide array of offenses. He starts off stealing chickens and he graduates to armed robbery. Well, the state of Oklahoma passes this law probably because of bunk scientific beliefs about the disposition of criminals to procreate and pass on criminogenic genes to their offspring. They passed this law that says if you commit 3 serious crimes from a certain list of crimes, then you'd be sterilized. You'd have to undergo a vasectomy. Now, Skinner appeals his sentence to sterilization. And by this time, I think the country was beginning to sit somewhat uncomfortably with the idea of sterilization, given its prevalence and practice among their enemies, the Nazis in World War II. You might recall that this case happened in 1942. The world was starting to become aware of the insidious effects of sterilization. So there's this movement against it. Now, again, we might be thankful in this case that the court disfavors sterilization for Skinner. Maybe they've gotten the right result. The reasoning struck me as manifestly odd, as I'm sure it did you. So the Supreme Court here holds that the Oklahoma law violates the Equal Protection Clause because it doesn't equally protect all kinds of criminals. So this is a very odd argument, but the basic gist of it is that Skinner is a robber. He's an armed robber. And other kinds of thieves, let's say, could be subject to sterilization. But one particular kind of thief was not subject to sterilization if they committed this crime 3 times. And that was an embezzler. If you violated the trust of someone for whom you were working and you funneled off money and kept it for your own and you appropriated those funds to yourself, you weren't in danger, at least, of being sterilized. And the Supreme Court held that because the law made this distinction between embezzlers and, let's say, petty larcens, that it unequally discriminated against thieves, let's say. And so it was violative of the Equal Protection Clause. And so Skinner got to keep his reproductive abilities after all. Again, a very odd argument. But really, I don't want to talk to you today about Skinner versus Oklahoma or anything like that. I'd like to talk to you about Griswold versus Connecticut. And in fact, Griswold versus Connecticut itself is not so interesting, but some of the themes that come up in Griswold versus Connecticut will be recurring for us in this course, especially as we turn our eye to Roe versus Wade in the coming weeks. In fact, probably the next lecture, if I remember correctly. So in Griswold versus Connecticut, here's what happened. Some physicians moved to Connecticut for the explicit purpose of challenging an ancient and unenforced Connecticut law. But eventually, it was enforced, wasn't it? What these physicians were doing was providing information to their patients about how to use birth control and contraception of various forms. Now, Connecticut only had a law that one shouldn't use contraception. They didn't have any specific law prohibiting information or something about that, but the attorney general or the prosecutor or whomever decided to prosecute these physicians for aiding and abetting, being an accessory to a crime. You might think getaway drivers don't commit the burglaries themselves oftentimes. They just sit in their car and wait. They're still tried as accessories to crimes because they aided and abetted those who did commit the crimes. That's the legal theory here from the state of Connecticut, is that these physicians are aiding and abetting couples who would dare to use contraception in the bedroom. And this law is especially odd to me because at the time of its enforcement, condoms were widely available for sale in the state of Connecticut. You could buy condoms legally, but they were marketed as disease prevention tools and not exactly prophylactics. And so condoms were perfectly legal as long as you were using them to prevent disease and not to prevent conception. Very odd law and a very odd state of things in Connecticut in the 1960s. Now, what the Supreme Court will ultimately argue in response to this legal controversy is they'll argue that the law under which the physicians were convicted is unconstitutional. And why is it unconstitutional? Well, according to them, it violates a penumbral right of privacy. There is a right of privacy, in other words, in the Constitution, and it comes from an emanation of a penumbra from the Bill of Rights. What the heck does that mean? Well, to put things in a little bit more perspective, when you look at the moon and it's a crescent, you can sometimes see a portion of the moon that's shadowed out. That's called the penumbra of the moon. Penumbra is supposed to be the shadow of something. And so we have this metaphor here that the Bill of Rights, the amendments from the Constitution, have a kind of shadow, and there are emanations from that shadow. So it's already very metaphorical language, but what exactly could that mean? Well, let's look at what the Supreme Court says explicitly here. They say, the foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one, as we have seen. Recall here that in a previous lecture, I told you about an argument in which privacy was thought to be implicated by the First Amendment. The argument goes a little something like this. Some organizations will not be disposed to meet if their member lists are disseminated. And so some kind of privacy is a prerequisite for full and free exercise of one's First Amendment rights to free association. Something like that. Okay, the Supreme Court continues on. The Third Amendment, in its prohibition against the quartering of soldiers, quote, in any house in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly affirms the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Okay, so what exactly is going on here? Well, here's what I think is going on. I think the Supreme Court is insinuating that when we read the Ninth Amendment and it says that the mere enumeration of rights in the Bill of Rights itself should not be construed in any way to think that these are all the rights that are out there in the world. The Supreme Court might think that on that basis, there are these rights sort of floating about that could be discovered by jurists, by judges, by those considering cases and legal controversies. Now, I think something like this pre-theoretical commitment, though often not explicitly stated, somewhat motivates the push to have the law degree be somewhat scientific. You know, the law degree in America is a doctoral degree. It's a professional doctoral degree. Oftentimes reference is made to the science of law. And just like scientists kind of go out into the world and might discover universal laws that help us make predictions about things, so too, you might think, the jurists discover natural rights or natural laws or something like that. Now, I'm not saying I completely buy this picture, and I'm not saying you should either. What I am saying is that it's oftentimes kind of in the background of a lot of people's minds when they think about what natural rights are and what the role of a judge is. Okay, so it's kind of a hokey picture, but it does have some kind of purchase, has some explanatory power. And I think it kind of explains why the court is reasoning in the way that they are. They think that there are these rights out there, and that the people who wrote the Constitution wrote down some of them. We call those the enumerated rights because they're written down, but there are other unenumerated rights, rights that are retained by the people, that are rights on which the government may not infringe. And just because they're not written down doesn't mean the government can infringe on them. But what exactly are these rights? They haven't yet been written down. They haven't yet been enumerated. They haven't yet been discovered. So how are we going to get at them? Well, that's going to be a puzzle in and of itself. But a natural suspicion for the Supreme Court here is that privacy and a right to it might be one of these unenumerated rights, one of those referenced from the text of the Ninth Amendment. People retain some rights. Why couldn't privacy be one of them? Now, the next step is to say, well, maybe it's not an unenumerated right. Maybe it is a textual right in some way. I have no idea what an emanation of a penumbra is, but it seems like the way the court is trying to justify their reasoning is by appeal to particular rights. They look at the First, Third, Fourth, Fifth, and even Ninth Amendments and try to make an argument about why this emanation of a penumbra generates somehow a right to privacy. So I have a big question about what kind of right the right to privacy is, but I do see the justification here. So either the right of privacy is one of these unenumerated rights referenced by the Ninth Amendment, or it's a kind of textual right, just kind of emanates from a penumbra of the rights that were enumerated. It's hard to know how exactly to think about the right of privacy. Is it enumerated if it emanates from a penumbra of the Bill of Rights? I have no idea. This is all vastly, highly metaphorical language. We're talking about shadows of text, which is almost impossible to decipher. And then we're talking about rights that haven't yet been written down that are retained by the people. I don't know the best way to think about this. Neither do you, neither do legal scholars. It's a puzzle for all of us. But what we see here might be enough for us to try to guess at what the Supreme Court means to say. Now, one way of interpreting this kind of argument is as inductive, right? Oh, look, in this context, the Constitution guarantees a kind of privacy in one's home. Oh, look, over here it guarantees a kind of privacy in one's home too. Therefore, in future cases, we would expect to see a protection of this same kind of privacy. Now, of course, the strength of this argument is probably also its weakness, because in some contexts, inductive arguments will be quite strong. Sometimes they'll help us to make useful predictions about what our observations will be, right? Suppose I go out into nature and I say, I've seen a black crow over here. Oh, I've seen another black crow. Oh, a third black crow. Wow. Maybe, just maybe, the future crows I observe will be black as well. I won't see any albinos, not very probably, at least. Seems like good reasoning, but of course it depends on the idea that one sample is sort of representative, right? If you go to the visitor section of an Ohio State game and you say, there's an Oregon fan, there's another Oregon fan. So all the fans in this stadium are probably Oregon fans. Well, you'd be misled because you're at an OSU home game and the fans are going to be Ohio State fans. You've just looked at an incomplete sample. So generalizations of this form seem a little bit worrying to me for that reason. So what exactly is the Supreme Court doing here? Is it saying, look, in the First Amendment, there's a kind of privacy guaranteed in the records to groups that might peacefully assemble. In the Third Amendment, there's a kind of privacy in one's home. In the Fourth Amendment, there's a kind of privacy in one's person, papers, effects, house, and things. In the Fifth Amendment, there's a kind of privacy in information that would incriminate oneself. Therefore, in future foreseeable context, there will be other analogous privacy rights in those contexts as well. And wouldn't you know it? What a married couple does in the privacy of their bedroom is one of those contexts as well. Seems to be an argument like that. But because it's inductive, it probably suffers from the same weakness that I just described. How do we know that these cases are meant to continue on and not be the complete picture? It comes up later in Justice Black's dissent, doesn't it? Okay, but let's set that aside for now. For now, the argument is there's this vague, undefined notion of an emanation of a penumbra. We have no idea whether that means the right is best thought of as unenumerated or the product of an enumerated right. I have no idea. I don't know what to do with that. And we've noted also that this kind of argument about privacy rights depends on the kind of generalization it seems. Now, in a later part of the opinion, Justice Goldberg's concurring opinion, we'll begin to think about what exactly would be involved in the epistemology, or how we could actually learn about the existence of these rights. That seems to be like the million-dollar question, doesn't it? So Justice Goldberg comes along and he says, what the majority has said so far seems plausible enough, but there's going to be this lingering question. The lingering skeptical question is, okay, jurists like us in the Supreme Court come along and we announce to the American public that we've discovered a new right, be it unenumerated or the product of an enumerated right. What is this right? Well, it's a right of privacy, we'll say to the American public. But the skeptic wants to know one thing and one thing only. The skeptic wants to know whether this right is a genuine right that was actually out there in nature and that was discovered, or whether it's just the product of a judge's political, religious, or moral bias that has infected what they've thought was a genuine human right. Okay. So again, going along with the hokey pictures, the judge is supposed to be in this little hokey, pre-reflective, pre-theoretical view of what a judge does. The judge is supposed to be this detector of human rights that are floating around there that are unenumerated, or perhaps even emanations of penumbras of enumerated rights. And the judge is supposed to be like a reliable detector of what these rights are. But for any right that a judge would announce, oh, I found a right, says the judge, there would be this skeptic waiting to kind of challenge that claim to the discovery of a new right. And what does the skeptic say? The skeptic says, this is just a product of your moral, political, or religious bias, and it's not a genuine human right at all. So what does the judge do? What ought he to do in light of this kind of skepticism? Well, Justice Goldberg proposes that we think not of the judge as someone who can arbitrarily announce new human rights to us, but instead as one who derives a right after conducting a series of tests. What are these tests? Well, the tests are whether a certain practice that is supposed to be protected by a right is, quote, rooted in the nation's history and tradition, or implicit in the concept of ordered liberty. So what you see following this statement from Justice Goldberg is the idea that rights might find their way into the constitutional law in a bunch of different ways. Because the Ninth Amendment says that just because certain rights are enumerated, it shouldn't be construed to think that there aren't other rights out there retained by the people. But likewise, the 14th Amendment says that one cannot be deprived of liberty without due process of law. Now, what sort of things are liberty? What sorts of practices does one have liberty in which to engage? That's an open question. And the idea is probably that whatever is a Ninth Amendment right is also a liberty that people enjoy. If something is protected by a right, it's a liberty that people enjoy. But could they come from different sources? Could you have a liberty that was protected by the 14th Amendment that was not a Ninth Amendment right? I have no idea. But it opens at least the logical space for four different ways for a practice to be thought of as a constitutional right, even if it's not written down, even if it's not enumerated. And what are these ways? Well, it might be a Ninth Amendment right rooted in the nation's history and tradition, or it might be a Ninth Amendment right that we've learned about because it's implicit in the concept of ordered liberty. That just sounds like mumbo jumbo to me at first pass, but as we move on in the course, we'll see some kind of attempt to explain what it is. Basically, the concept of ordered liberty involves a weighing of one's freedom to do something with a government's interest in curbing that behavior. So suppose that freedom of religion is a good thing, but that one's religion involves a kind of practice that's very disruptive, such as the Santeria cult. I think in a famous case in Florida in which they sacrificed chickens to the horror of the neighborhood. Suppose one's religion is protected by the Constitution, but also suppose that you're engaging in these grotesque rituals and that people are kind of appalled by it. Where does, in other words, one's right kind of stop because of another's interests? When we try to figure out answers to these questions, we're thinking about ordered liberty. So when we think about ordered liberty, somehow we can generate maybe a right that's not explicitly written down in the Constitution. We can generate an unenumerated right. The other way we could do it is just by appealing to the 14th Amendment text. Just as the Ninth Amendment implied that there are rights retained by the people, the 14th Amendment implies that there are liberties of which one may not be deprived without due process of law. And how do we figure out whether one of these things is the kind of liberty that the 14th Amendment is designed to protect us in enjoying? Well, we again can appeal to the idea that maybe a practice is rooted in the nation's history and tradition, or that something is implicit in the concept of ordered liberty. So all we've done in this example is we've thought through what Justice Goldberg has said. Okay, the majority opinion in Griswold versus Connecticut says there is an emanation of a penumbra and it generates a constitutional right of privacy, and that constitutional right of privacy somehow makes it unconstitutional for the state of Connecticut to make law prohibiting the use of contraception among married couples. That's the story. Now, Justice Goldberg, and what I've just been telling you, is worried about that strategy because it seems to license ad hoc announcements about what sorts of things are constitutional rights. How do we ever know if something is just the product of a judge's political, religious, or moral bias? It might be something that they just made up. So Justice Goldberg wants us to satisfy the skeptic by appealing to these objective tests about whether something is rooted in the nation's history and tradition or implicit in the concept of ordered liberty. Both of these would be avenues for showing that something is not just the product of a judge's mind, but are in fact grounded in something else, something objective, something that goes outside the judge. And yet, Justice Goldberg never seems to give us a very clear explanation of how privacy is rooted in the nation's history and tradition. And likewise, another judge who announces that the right of privacy is implicit in the concept of ordered liberty never really unpacks that argument for us. They just sort of say it. That leads us, I think, finally to the dissent in Griswold versus Connecticut. Hugo Black is among my favorite jurists for his political philosophy and for his juridical philosophy. He's a very consistent judge across time. And I'm not sure if I agree with him, but he's one of my favorite interpreters of the Constitution just to read, I think. And he basically says what I think is interesting. He says, this law from Connecticut is undeniably silly. But then Black expresses this kind of skepticism toward the machinery that Goldberg just announced for ascertaining whether something is an unenumerated right. He said, where are you getting all this? Where are you getting all this rooted in the nation's history and tradition stuff? I didn't come from the text of the Constitution. That's just something that you've made up. Um, it's bogus, right? He's questioning the very source of the Supreme Court's right to engage in these historical analyses about whether a practice is rooted in the nation's history and tradition. He doesn't think the Supreme Court has the right at all to examine the nation's history and tradition and then announce as a right those practices that might be observed to be in the nation's history and tradition. He also doesn't think that the Supreme Court has this kind of prerogative to reflect on the concept of ordered liberty and then make judgments about what sorts of practices could be protected by it. He basically views the Supreme Court as a body that's supposed to protect against the infringements of the enumerated rights, the amendments that were explicitly written down. And his doing so is a kind of textualism. So, in summary, he basically says what Connecticut has as a law is undeniably silly and ought to be a law. It ought not to be a law. However, the Constitution and the text itself does not contain any express prohibition against making of this kind of law. And so basically, it's outside of the jurisdiction of the Supreme Court to strike it down. And that was his decision. Okay. Now, why is this case of interest to us? Well, in the coming lecture on Roe versus Wade, we'll see how the court basically, without referencing Griswold versus Connecticut at all, announces that the right of privacy discovered here, quote unquote, extends to a woman's decision to end a pregnancy. And so in a later writing assignment, I'm going to ask you one question about this. I'm going to ask you what the court's reasoning is in Roe versus Wade, and I'm going to ask you why they think that there is a right of privacy in the first place. And when you answer that question, it's going to be critical for you in order to do well on this assignment to remember this paragraph right here. This paragraph right here is an explanation about why the court thinks that there is a constitutional right of privacy. They look at the amendments and they say something about emanations and penumbras, and from that talk arises this right of privacy. But the story is rich. The story is, in order to freely exercise their right of association, organizations need to keep their membership lists private from the government, particularly the NAACP, as occurred in a famous case, right? The Third Amendment guarantees people the right to be secure in their homes in a time of war. Fourth Amendment guarantees people the right to be secure in their homes against unreasonable searches and seizures. You have this right of self-incrimination and so on. And so from all these, we can make this generalization that the Constitution protects privacy. That's why the court in Roe versus Wade ultimately finds there is a right to abortion that is grounded in the right of privacy. And on the writing assignment, I'll ask you basically to explain why the court in Roe versus Wade is depending on that kind of an argument. And to do that, all you need to do is come back here to this excerpt from Griswold versus Connecticut and review how the amendments are in some way supposed to generate this penumbral right of privacy. You needn't take any stand, as I just said, on whether this is an unenumerated right of the kind protected by the Ninth Amendment, or whether it's supposed to be a textual right that's generated from the Constitution itself. You didn't take any stand on that, but what you do need to tell me on the second writing assignment is why the court in Roe versus Wade thought there was a right of privacy. Okay, covered a lot of ground. We've covered the cases that led up to Griswold versus Connecticut. We've covered one main argument from Griswold versus Connecticut itself, and we've covered different amendments and proposals that Justice Goldberg made for understanding whether something was a genuine constitutional right. And then we've looked at Hugo Black's skepticism toward the whole enterprise. I hope you learned a lot from this lecture. I hope you enjoyed it. And see you next time when we discuss Roe versus Wade.